Hi, everybody. It's Brad LaMorgese, and I wanted to talk about when can you use mandamus in Texas family law, and it's a frequently misunderstood topic. So, one of the most biggest misunderstandings of this remedy in family law is the petition for writ of mandamus. Many lawyers hear the term and think of it as an appeal, but it really isn't. A mandamus is better described by sort of an emergency proceeding or appeal that happens while a case is actually pending, not after the case is over. To obtain mandamus relief, you generally have to show two things. The trial court clearly abused its discretion, and there's no adequate remedy by appeal. The second element, no adequate remedy, is actually pretty critical. Appellate courts want to know why waiting until the end of the case and pursuing a normal appeal wouldn't adequately protect the complaining party's rights. Texas courts repeatedly describe mandamus as an extraordinary remedy, not an ordinary remedy. So, what can we use a mandamus for in Texas family law? Number one, really, temporary orders is the most common family law mandamus. The reason is pretty simple. Temporary orders cannot be challenged through an appeal. And the Family Code specifically states that temporary orders are not subject to an interlocutory appeal. So, if the trial court enters a temporary order that clearly violates the law, mandamus may be the only realistic avenue for appellate review. Examples would include temporary custody rulings that exceeded the trial court's authority, temporary possession orders entered without required statutory findings, orders entered without required notice or due process, temporary orders maybe that clearly violate statutory restrictions. Because the case is ongoing, waiting a year or two for a final trial and then appealing may not adequately protect the affected parent or child. So mandamus may be the actual real remedy there. In modification cases and temporary custody changes, this is an area where you'll certainly see successful mandamuses. In modification cases, the Family Code places significant limits on a trial court's ability to change primary residence during the case. The legislature has deliberately made it difficult to change it, the parent with the exclusive right to establish the primary residence. And that makes sense because if essentially you have a trial before the trial, it's not terribly fair to the final order of the other parent. And so typically you have to wait to the end to get a change of custody. And keeping in mind, certain of those decisions are actually subject to a jury's decision. And so, you wouldn't want to deprive the jury of that decision either. This can include a change of primary custody, altering a geographic restriction, ordering or preventing a move away. That can effectively change the dynamic of the final order, and that's limited by the Family Code. Another thing we see quite a bit is potentially even a change of schools without satisfying statutory requirements. So many of the successful mandamuses come from this area. Another category is discovery. This is sort of the age-old mandamus. Most discovery disputes are not good mandamus candidates. Appellate courts generally don't want to micromanage discovery. However, there are exceptions, and they may be appropriate where the court orders the production of privileged documents and the genie would be out of the bottle. Trade secrets, highly confidential information, those are typically subject to protections. Or if the court orders an extraordinarily broad production that might cause irreparable harm. More commonly, if the court really denies discovery that's essential to presenting a claim or defense, the court may be able to help there, the appellate court. The key question is whether the damage can be cured by a later appeal. If the information is disclosed today, the bell can't be unrung tomorrow. Or if the information is not disclosed, it's not going to be a very good trial if the court has held back significant information. Also, cases where a judge would exceed their legal authority, those are strong mandamus candidates. Those would include, for instance, where a court lacks jurisdiction, where a court enters an order after jurisdiction's expired, where a court might disregard a mandatory statutory requirement, or if the court acts outside of its scope or legal authority. Those issues frequently present pure legal questions. So Court of Appeals tend to be way more receptive to mandamus relief rather than issues of factual callings by the judge. So another area worth mentioning is mediated settlement agreements or maybe some sort of other binding agreement. Texas law generally provides that a party is entitled to a judgment on a mediated settlement agreement or one of the other binding agreements. The Dallas Court of Appeals recognized circumstances where mandamus review is appropriate when a trial court improperly refuses to render judgment on an enforceable mediated settlement agreement. Of course, those cases are fact specific, but lawyers should remember mandamus is not limited to custody or discovery issues, and that's an interesting newer area. So the reality check. Mandamus is really hard. One thing lawyers need to understand is the odds are stacked against the relator, the person filing. The standard is not merely was the judge wrong. The standard is whether the judge clearly abused his or her discretion and whether there's no adequate remedy by appeal. And that is a high bar. Most bad rulings are not mandamus-worthy rulings. Most discovery rulings are not mandamus-worthy rulings. And most temporary orders in a regular divorce are also not mandamus-worthy rulings. There has to be something more significant. Practical considerations. So before filing a mandamus, ask yourself, have I preserved error? Do I have a sufficient record? Do I have the transcript and do I have the order from the hearing? Can I clearly explain why an ordinary appeal is inadequate? And is this truly an abuse of discretion, or do I simply disagree with the trial court? Remember that unlike a traditional appeal, the parties create the mandamus record themselves. The record must be assembled, organized, and often carefully redacted before being submitted to the appellate court. You see opinions all the time where they're rejecting the records, especially in family law cases. Mandamus proceedings move quickly, but they require significant work, and I would argue even more work than a regular appeal. So in closing, the takeaway is simple. Mandamus is an extraordinary remedy for extraordinary situations. In Texas family law, the most common uses involve temporary orders, modification cases involving custody changes, serious discovery disputes, jurisdictional errors, in situations where the trial court has exceeded its statutory authority. If you're considering a mandamus, start with one simple question. If I wait until a final appeal, will the damage already be done? If the answer is yes, you may have a good mandamus case. If the answer is no, you're probably looking at a traditional appeal instead. So I would say don't necessarily be afraid of mandamus, but also be realistic about the chances and look at other instances where the courts have already granted mandamus to see if your case is that kind of a similar situation. So mandamus is hard, but not impossible. I've certainly participated in numerous mandamuses, and it is a viable remedy, even if it's a hard one.